My Lords, it's a pleasure to follow the noble Lord, Lord Blunkett, and in particular to follow him in expressing a very large degree of gratitude to the government. I think although one is going to end up disagreeing with the government on certain narrow points in the course of this short debate, the fact of the matter is the government has introduced amendments in the Commons which are extremely helpful to IPP prisoners who are out on licence, and today amendments have been introduced which deal with the very good points made by the noble Lord, Lord Blunkett, and by the noble Lord, Lord Carter of Hazelmere, allowing them to withdraw their amendments. And I don't think it is at all an exaggeration to say that more has been achieved in both operationally and legally for IPP prisoners in the last few months than in the preceding 12 years. And I wish to say that I'm sure a great deal of that is due to the personal efforts both of the Lord Chancellor but also of my noble and learned friend Lord Bellamy on the front bench. So I wish to express that gratitude and that degree of congratulation. I also want to say, and here I find myself again echoing the noble Lord, Lord Blunkett, that I am very impressed with the effort and determination of the officials charged with taking responsibility for clearing up this scandal, that they really wish to do something, and I wish them well, and I hope that continues for as long as it needs to continue, whatever the character of the government in power. Before I turn to the amendment standing in my own name, which is number 145, I do wish to say, though, that there are some amendments in this group tabled by backbench peers which have not found favour with the government, and mine, number 145, is one of them. But so also is that standing in the name of the noble Baroness Lady Burt of Solihull, and which is number 140, and number 147 in the name of the noble Baroness Lady Blower. And I simply wish to say it's not for me to make their speeches advocating their amendments, but simply wish to say in advance of their doing so that I would be very much supportive of what they're trying to do and what their aims are in those amendments. Amendment number 145 in my name was not actually drafted by me. As noble lords who were present in committee will remember, it was in fact drafted by the late Lord Brown of Eton under Heywood, who felt passionately about this, and coincidentally whose memorial service is happening later this week. On social media, it has in fact been dubbed the Simon Brown Memorial Amendment as testament to the passion that he brought to this particular topic and the efforts that he made. I'm not going to divide the House on this for two reasons. The first is that despite indications otherwise perhaps in committee, I understand that the Labour Party would abstain on this amendment if it were pressed to a division. But I do wish to make a few remarks about it. First of all, to remind noble lords what it does, and that is that it does two things. It reverses. Now, I'm going to use the words in a non-technical sense, not being a lawyer, but it reverses the burden of proof in front of the parole board, so that instead of the prisoner having to demonstrate he or she is safe, it will be for the parole board to demonstrate that they are in fact dangerous. Now, there is nothing radical about this proposal because the power to make that change was already given to the Secretary of State in the Legal Aid Sentencing and Punishment of Offenders Act in 2012. And so all that this part of the amendment does is, so to speak, to trigger that and to oblige the Secretary of State to make a change that he is already empowered to make. The second thing that the amendment does is that it introduces a test of proportionality which the parole board can apply. And I will turn to that in just a moment. I am not going to repeat the arguments I made in committee in favour of the amendment. But while the noble Lord, Lord Thomas, noble and learned Lord Thomas of Cumgeed, couldn't anticipate what the Minister was going to say at the end of this debate, I can actually refer to what he did actually say in committee, specifically on this question of proportionality, because it's here in Hansard for the 12th of March in column 1965. And my noble and learned friend on the front bench, Lord Bellamy, said, "The government's position, frankly, is that the word proportionality causes more difficulties than it solves. And the crucial words are, it suggests that the test should be some sort of balance between the risk that the prisoner may present to the public and some sort of fairness or other consideration of the particular interests of that prisoner." Well, I think my noble and learned friend has put it exactly as I would put it. And indeed, there is a huge difference between prisoners who have been given a determinate sentence and who, if they are refused parole, will nonetheless be released at the end of their sentence, whatever the risk, and IPP prisoners who, if they are refused parole, are returned to an indefinite sentence. And fairness is a consideration. Justice is a consideration. And I think many noble lords understand that completely. And it may be the case, as my noble and learned friend went on to say, is that the public protection test is a public protection test. That is the only criterion, as far as this bill is concerned. But that, as I say, while that might be appropriate to prisoners with determinate sentences to have that as the only criterion, it is not appropriate for IPP prisoners, and some sense of fairness and justice does need to be brought into play. So, the second reason I will not be dividing the House is, of course, that, as he has already explained, the noble and learned Lord Thomas of Cumgead, has tabled Amendment 149A, which drops the question, the issue of burden of proof, as I had, and focuses solely on this point about proportionality. And I'm persuaded by his arguments that is the key point. It also might be easier for noble lords to vote for a trimmed-down amendment that focuses on that very narrow point. So if the noble and learned lord does, as he has indicated, divide the House on Amendment 149A, then while I will not be pressing number 145 to a vote, I will join him in the lobbies on 149A.